Well, yes, indeed, Mark, but we've got Mr. Osaro Ehobamie here with us. He is a senior advocate of Nigeria. Good morning, and thank you for coming on this morning.
Thank you very much.
Well, yes, we're focusing on the judiciary now. We do know that, yes, there's been several judgments several weeks ago, many of which people are still talking about. And you know how it is in that particular arm of government, how very important it is. But when you see people respond, albeit negatively, to judgments that have been handed down by courts when they protest, if I could use that word, does it come across to you as though either they don't understand how judgments are arrived at, or they just think, no, something is wrong here, and they could have a point, or within their rights to protest?
Thank you again. Protest is the word you ask.
Yeah.
I think the place to start is, and I think you have the Imo judgment in mind, all right? I think the place to start is when a decision is delivered and it perhaps raises some sort of controversy because you're talking about an election petition. The question to ask is, does that decision, is it in accordance with what we understand? So for those of us who practice within this court, we should be able to give an opinion as to how the court is likely to, the decisions that the court will likely reach. And a good or prominent lawyer worth his name should be able to give an opinion that is anything between 80 and 95% correct. I think some of the decisions you have at the Supreme Court may not necessarily accord with what my opinion might be, you know. So I think to that extent, well, okay.
The layman's opinion.
Well, there are two things. The lawyers who practice are finding it very difficult to practice within the system, because the first thing you do when a set of facts comes to you is to give an opinion as to what you think the outcome would be. Really, we apply a discretion. It's not every case you take to the Supreme Court. But these election petitions, you find out that all the governorship cases will go all the way to the Supreme Court. It's almost like a gamble, hoping that you succeed. And indeed, in one or two of the cases they did succeed, and that continuously encourages others to go there. When you succeed in a case of that nature, that case must demonstrate scholarship. It must be a case that sets a policy, especially when it departs from other cases, and I mean in terms of the other governorship cases. So, without going into the nitty-gritty of the case itself, I think there's a more fundamental problem that we're faced with.
Well, what is it?
And that it's that there is a systemic failure. The Supreme Court is constrained. So when I read that decision, the decision effectively overturned two lower courts decisions. So effectively it was saying the facts that was analyzed by those courts, especially the tribunal, these facts were perverse. That's the test. Now, if the facts are perverse, you must go into detail. What I didn't see on the face of the judgment was the detail as to why the Supreme Court arrived at that decision that it was perverse. It simply said it disagreed. And, you know, election petition cases, there are many conflicting decisions now, and that's not good. So I would rather focus on the fundamental problem. These are symptoms of a deeper problem.
Which is?
Which is that the judiciary, the justice delivery system has a problem. In fact, you know, I'm running 42 kilometers. I thought that's what you were going to focus on. I'm running 42 kilometers to draw awareness to the complications and to the complexities that we're now confronted with as a result of perhaps neglect.
Of the judiciary, or what?
Of the entire administration of justice system.
When you say neglect, you know, just before the ACJA came to be, there was that concern, huge concern, and then they thought with the introduction of that, you'd have thought that that will have huge impact. I don't think it still has an impact on the administration of criminal justice system, the ACJA. And so, do you still maintain your view that it's been neglected even though you have the ACJA?
All right, the ACJA promotes very good rules, but the infrastructure for it to work is absent. So let me give you a typical example. If an accused person is being interviewed now in the police station, it must be done under the cover of a camera. And if it's not...
That's what it provides for?
Yes. I don't know how many police stations have any camera. And if it's not, that evidence is tainted to the extent that the trial court may not accept it. But I don't know anywhere that it's being complied with. It's complied more in the breach than in observance. So there's a lot of fiscal infrastructure that comes along with promulgating rules. Both must go together. But I agree with you to a large extent. Policy is absent completely. The Supreme Court is a policy court. It's not there to decide between just two individuals. It pronounces the position of the law, which guides all of us. Now, when the Supreme Court is dealing with so many cases, it becomes constrained to actually apply scholarship because you don't really have the time. Therefore, we have to start looking at that very carefully. It has to be constant. What we do must be under constant review. That I don't think is happening. Look, it happened in Lagos State before. I recall when I was practicing, I'll go to a court, and you have 150 cases on a Monday morning. Impossible. The judge will probably get to 24 and adjourn all other cases. Now, then came the vice president and Arthur Warren. And they worked with a number of practitioners. Some of us provided our services pro bono. I sat in the trust committee and quite a few others. And the system changed. So Lagos has a much, much improved system. It could be much better, but we are far better and more improved than where we were. Now, when it comes to the Court of Appeal, Supreme Court and other states, I'm not sure that this system is under the kind of review that one would like. It has to be constant review. Look, the markets are dynamic. And therefore, also you have to ensure that the rules that pertain to them, the regulatory framework is also dynamic. Must change.
Now, just before we move on to some of the issues you have raised earlier on, you touched on the fact that you say that, having cameras, for example, during interrogation, I should say, is being observed in the breach. And I'd like us to, ensure that this is sorted out. Whose responsibility is it to enforce that particular provision, ensure that across all police stations you have this kind of equipment on ground?
It will be a combined... and this is the complexity you face. It will be a combine of the Attorney General's office, of course the police, the executive, because they have to provide the funds. So the way the judiciary is funded is also part of the problem. We talk about independence of the judiciary, financial independence, but no one asks whether or not there's accountability on how that money has been spent. So you have a chief judge who becomes a chief judge because perhaps he's delivered very beautiful judgment. That doesn't mean he's a good administrator of funds.
Does he administer the funds?
Well, in a way, I think he gets involved in even sanctioning the supply of stationery. I don't think that should be...
But ideally, that shouldn't be the case.
Well, in other parts of the world, you have demarcated the administration of the court business with delivering justice. They're two different things. And it's a huge thing. So if the court's premises were to be leaking, for example, and the judges were supposed to go on a training in Canada, what stops the chief judge from saying go to Canada instead of fixing the courts that's leaking? In my office, I probably fix the court first. But there's nothing, there's no guideline, there are no policy rules as to how these monies should be deployed.
So is that why they say sometimes that, the judges are overburdened?
Okay, pardon me. We need to go to break, but we'll be back in just a moment. Stay with us. All right, welcome back. So let's take it from where we left off. And you had a question.
Earlier on, you mentioned judges being involved in other roles like administration of funds. And I was asking, is that why there's this saying that, judges in Nigeria are overburdened, perhaps?
I think they're not only overburdened. The system and the judges are stretched to breaking points. The system is almost collapsing. So let me give you an example. Now in the Court of Appeal, for a simple application, not the judgment, you're getting adjournments for a year, 2 years. And when that date comes, there's no guarantee that the matter will be heard on that day. Now, if there's anything that demonstrates justice delayed, you cannot give me an example other than that. Now, there are institutions that are created to continuously review the situation, to ensure that the judges are efficient, to ensure that the system is efficient. Those institutions themselves require reforms. And therefore, I joined a group of other senior lawyers and like-minded citizens to set up an NGO. That NGO is known by the name of Justice Reform Project. The Justice Reform Project is to complement the institutions that are supposed to effect reforms, but recognizing that those institutions themselves require reforms. You see, it's quite difficult when you're part of a system sometimes to remove yourself, to understand that you are also part of the problem and you need to reform. And I think that's where we've gotten to. You see, we have a lot of institutions that are saddled with the responsibility for reforms. So there's the NJC, there's the Federal Judicial Service Commission, there's the Law Revision Commission, there's the Ministry of Justice, you name it. Institutional inhibitions, I think, will cause these statutory institutions to fail in their responsibility.
Okay. One of the things that I wonder, is, so you've mentioned these institutions manned by people who ought to know what to do, expectedly. Is there a program, is there a schedule, is there a timetable, so to speak, where some things are supposed to happen within time so that these reforms don't have to happen offhand or off timing, so to speak? Because you mentioned earlier how these things happen in other climes. Why is it not happening here? Shouldn't we have a schedule of reform or review of our practices over time so that we don't get to the breaking point that you mentioned earlier?
A combination of reasons. If you look at many of those institutions, how are people appointed to those institutions, including the bench? How are people admitted to practice law? Law is a learned profession. It's a rigorous profession. It's a calling. So once you're admitted to practice law, from that group, you're elevated to either being a judge or you're appointed into any of these institutions. The process of appointment needs to be looked into so that you get the right people. It is a profession that requires thorough intellectual discipline.
What would you propose in terms of bringing people into these levels that you're talking about?
Well, first of all, you must have the character. It's a vocation. You must have the character that's required to not only practice law, but to be elevated into any of these institutions, particularly the bench. And the truth of the matter is I see people who tell me they want to go to the bench. Most don't understand the rigors that it requires, and then the discipline in terms of your character. Now, when you see a judge, I remember when I was growing up, my father is also a judge. My father is a lawyer. He's a senior advocate of Nigeria. And I remember a day that a judge drove past the house. He just stopped by at the gate. My father was like a kid running around. We're all running around because we're so petrified that the judge stopped. That was the kind of respect. Now, if today I'm sitting in a party and the judge is not conducting himself properly, I'm not going to have respect for that judge. So the character that it takes to sit on the bench or to sit in any of these institutions sometimes is lacking because the method of appointment is opaque.
Well, isn't that part of the requirements as it stands right now?
All right. The requirements are basic. So if you've practiced for 10 years and if you've, in this case, let's say going to be a judge, if you can demonstrate that you've delivered judgments. I'm not sure about the quality of the judgments, but if you've delivered 10 judgments. So it's a form rather than substance. And that's what is being demonstrated all the way to the Supreme Court. The jurisprudence is becoming quite weak. And let me explain what I mean. If I signed a document, and it will amaze you, and I signed it wrongly, or I used a stamp of authority to sign it, your matter can travel all the way to the Supreme Court, and at the Supreme Court, it will be decided on the fact that I haven't signed in accordance with the way I, as a lawyer, recorded my name in the call list.
And that may have taken years.
25 years. Now, tell me what that has got to do with the merit of the case. And if indeed you are concerned about fake lawyers, you have the lawyer who is there to sign it correctly, or he swears an affidavit to that extent, or you punish him, not punish the client. That's not jurisprudence. But I tell you why that is happening, because the judges are constrained and there's no time to apply rigor.
Now, you talked about practice the other time.
Yeah.
And from what you have also said, lawyers grow through the ranks over time. That means then, if it's the practice that produces these promotions,
correct,
then there is something wrong with the practice.
A combination of things are wrong. Even the code of conduct. We sign up to a code of conduct, but it's not verifiable. In other words, if we don't comply with it, nothing really happens. So the NBA is now too large to instill any discipline. I was qualified to practice in the UK in 1989, and I worked there, and I actually did the vocational courses. So the Inns of Court are the institutions that apply those sort of disciplines. There are many things that I will do here. I would never get away with it in the United Kingdom. So we have to introduce a level of discipline amongst lawyers. I can tell you something. If a lawyer were to be acting for you and he did anything that was unbecoming, you will be quite suspicious. And if you took him through the disciplinary process, you'll be frustrated. So we need to review the entire system so that we have people of character practice law and are elevated within the system.
But if you would say this is where, because I mean, the review might sound like a lot of work. If you say this is where we need to start from, I mean, reports have it that from 17 we had the justices reduced to 13 as we stand right now. And we hear that some names have been forwarded to the president and nothing has really been done about it. But you mentioned also the process of even getting into the practice in the first place. So where should this start from, you know, across the value chain, as it were?
Sometimes it can appear overwhelming. But let's take the issue of appointment to the Supreme Court. Many of us have advocated that there are quite a number of distinguished and prominent senior lawyers who could be elevated straight to the Supreme Court and will infuse a level of intellectualism that is refreshing. But only recently, the Chief Justice of Nigeria said, no, that's not likely to happen because people have stayed within the system, and therefore there are judges who are in the High Court, Court of Appeal, who are looking to go to the Supreme Court. Now, this service, justice delivery, it's not like any other service. Merits is imperative for you to demonstrate merits. It's just like a doctor who treats you. And if the doctor is not well qualified, or if the doctor comes from Zamfara State, it won't matter to you. So also with law, what does it matter? Whether or not you come from a particular part of the country. What matters is that you have the capabilities and the abilities to dispense justice without fear or favor. The current system doesn't really sift such that you get the best. So we can start with the methodology of which you appoint judges all the way to the Court of Appeal, Supreme, and the High Court, of course.
All right. Well, we'll continue this conversation in just a moment. Please stay with us.
Before now, Delta State was zoned to the Benin Division of the Appeal Court, leaving justice seekers with challenges of long-distance travels to court, in addition to costs of transportation, delay in the dispensation of justice, and congestion of courtrooms. To address these challenges, the state government has built the 17th Division of the Court of Appeal in Asaba, inaugurated by the President of the Court of Appeal. Justice Zainab Lokachua is led by the Delta State Governor Ifeanyi Okowa as she commissions the e-library named after her, unveiling the Statute of Justice.
In the judiciary, expansion, though the establishment of new divisions is an aspect of the judicial reform agenda, which is to enhance access to justice and speedy disposal of cases, as well as efficient administration of justice.
They proceed for an inaugural court sitting, which coincides with the valedictory court session ahead of her retirement in March.
It has been a priority of this administration since 2015 to extend the frontiers of justice administration and bring it closer to the people for the purpose of fairness, equity, and timely service delivery. The opening of this court today further demonstrates our commitment to the rule of law and social justice.
Members of the bar and bench congratulate her, but also use the opportunity to bring up some of their challenges.
Call for a concomitant amendment of the provisions of the Court of Appeal Act to allow for the appointment of sufficient number of justices that will ensure that no division of the Court of Appeal will have less than 6 justices posted thereto, and particularly overworked, and the particularly overworked and overloaded divisions like Lagos, Abuja, and Port Harcourt will have no less than 10 to 15 justices.
The Court of Appeal presence in Asaba comes with a new hope of justice administration that is close to the people of the area for the purpose of fairness, equity and timely justice delivery.
Welcome back. We're continuing our conversation on administration of justice and what do we do to improve, because, I mean, when that does improve, of course, it will have an impact on the larger society. Well, we've since been joined by Mr. George Eke, who is a legal practitioner. Thank you for coming on this morning.
Thank you so much.
Well, if we could continue from where we left off, speaking about methodology, but, you know, we look at other climes and see what happens where we're constantly looking to improve in every sector. In some of those other climes, do people have a role to play? Do we have a role to play here in Nigeria?
Everyone has a role to play. And, you know, I continuously digress into justice reform projects. You journalists have a role to play. When I see journalists ask a question to a lawyer who hasn't read a case, what is your opinion? And the journalist is ready to receive that opinion without saying to the gentleman who's a lawyer, you haven't read it, you can't give me an informed position. I am embarrassed. But beyond that, the journalist should and ought to read the records. And don't take what I say for it. This happens a lot, and I see people misrepresent facts when you can simply verify those facts. Now, the practice of law, I said before, is rigorous. It is tenacious, and I am running a 42-kilometer marathon. I'm 53. I don't know, I need to say that because, you see, you asked a question.
By mistakenly putting myself in the 9 of 5.
Yes, you did.
But we're looking at the larger society. in some claims, they elect judges. Some of them insist on how some of these things should go. They insist on the way reforms should go. In that context, what role do the people have to play?
When we use the word administration of justice, extremely broad. That's the point I'm making. There are some areas that are remote. The consumers of the service would be in a position to tell us when we're reforming the process. What has happened in the past is reforms are done just by lawyers. When you do that, you don't actually understand how it impacts on those who are consuming that service. It's a service, albeit a service that is constrained to the extent that you don't have a choice. I mean, you can go to arbitration, but even arbitration would end up in a court system. Now, what you expect of the lawyers, what you expect of the judges, is important that we have those empirical evidence, and then we use it to reform the system. So I say that everyone has a part to play. But the journalists, you play a typical role. In other words, you need to get to a point where you're reporting to us what is happening in courts, and that's why we're inviting you to a place like JRP.
Are we allowed to do that? Because sometimes they tell you, no, when you get into the court, you can't show the faces of those judges while they're delivering those judgments. And those are some of the restrictions that we've got.
Those are some of the things that JRP will look into. It's a public court. It is true from the old English methodologies, you are not allowed cameras into the courts. But we see no reason why you shouldn't. These are the sort of reforms because
so maybe we'll have to take on JRP on that.
Yes.
So they can allow the people to see how some of these things happen.
Look, there are many things that JRP will be doing, including making the system more transparent and open. And we'll be pushing for that. And that is why JRP is not just for lawyers. You know, the origin of JRP comes from the fact that 18 or 20 lawyers had signed a document asking the then Chief Justice to more or less remove himself from that position.
Well, Mr. K, you know, we spoke about the ACJA, operationalizing it. I mean, Mr. Obama didn't tell us that it provides that there had to be cameras in police stations when you're taking some of these cases. But on a lighter note, you never told us, we love cameras in some of those places, but do you think that with the way the ACJA is being practiced at the moment, what kind of impact would you say that has had in the administration of justice?
I think it has quickened, the justice administration system in the sense that, quite a lot of reforms, that are introduced by the ACJ, to some reasonable extent are being adhered to. And to that extent, we are working towards a particular direction, and that direction is quick dispensation of justice. And it keeps everybody on his toes, the people at the bench and those at the bar, as it were. Like when it was not there, when all manners of things happened and, the practice was particularly not as regulated as it is now. So it is, quite positive, and the impact is, as we see it today, quite reasonable. But we can do better than that. I mean, it's a work in progress, as it were, and the room for improvement is always there. So that's what
picking it from that room for improvement. I think, most legal practitioners will agree that there's need for some form of reform. But, the way and manner it should be, approached is usually a tricky thing. So, Mr. Ahobamia here, you spoke about, having a top-to-bottom approach. Let's start from the way we even, put Supreme Court justices in place, have, intellectuals, fresh minds. And I'd like to bring you in on that. How should we approach this reform? What methodology do you think we should use?
Well, you see, in quite a number of climes, you find out that people who have done very well, in the bar, they are quite at home with the justice system. And they can be allowed, or at least admitted to the bench. That is to say, very senior lawyers can become justices of the Supreme Court. But this, we're finding it difficult here. There have been foot dragging on that matter. In short, we almost got there, quite recently when, a number of senior lawyers were, nominated or at least wanted to get to the Supreme Court. But it looks like the system is either that is resistant to it or is foot dragging, kind of. So that is why we're saying when bright minds come to the Supreme Court, they also come with their own, ideas, as it were, and infuse one of those things that we at the bar, have been looking for or looking towards and all of that. But you see, legal practice is such a conservative, industry, if I might use that word. It's such that everybody wants to continue to see if we can continue to retain what is there, and it's difficult to. If there is anything that is being resisted, it's the change. You get the point, but we are getting there, no doubt.
When you say the system is resistant, what part of the system are you referring to? I mean, the system sounds a bit broad. What part of the system?
Oh, like I just mentioned, when we're talking about reforms, one of the issues we're talking about is this idea of having to allow people from the bar to the bench. You get the point? In quite a number of climes, it is an easy thing to do. You get the point. You just apply. In places where they do election, you probably stand the election and get elected, to probably the Supreme Court. Supreme Court is where we are talking about now, because ordinarily, I mean, people from the bar just get to the bench, at the level of judges and all of, because that's where the recruitment ground is, is from the bar to the bench. But we're not talking about joining the high echelon of the judiciary, i.e. the Supreme Court. That's where we're talking about, and that is where I think it is not as smooth as we would have wanted it.
And how does that help to give teeth or credibility to dispensation of justice?
It helps in the sense that, okay, these are fresh minds, like we have always advocated. These are fresh minds. Yes, you may think that they probably do not have the bench experience, as it were, but these are people who have been appearing, in court for as long as some 40 years behind them, sometimes 30 years and all of that. So they know the nuances and of legal practice and, judicial administration, as it were. And if they do come in, that is how it's going to help.
Okay. Mr. Obama, one of the purposes that the ACJ was supposed to perform is speedy dispensation of justice.
Absolutely.
How easy or otherwise is it operationalizing that?
Well, thank you very much. And that's the point. The NGC should have a policy. So if you ask me today, what is the policy for decongesting the courts that are overburdened? What is the policy? We can disagree. We can be polarized about what step to take. But I don't even know what the policy is, and I'm a stakeholder in the system. So the first thing I expect, Attorney General working with the National Judicial Council, is to say, look, the Supreme Court is seriously overburdened. What are we going to do? There are many options. You can argue against some of them. And the Supreme Court is a policy court. You asked a question to my colleague here. You said, how would it change the situation if you got fresh minds? Don't get me wrong. There are some very bright minds in the Court of Appeal. But the system of elevation, one is not clear, apart from the very regimental basic requirements. So you may not necessarily get the brightest of minds. But so those of us who practice say, okay, look, you need to get us a bit more involved. There has to be a policy in the NGC to say this is how we're going to do it. JRP wrote a letter and said, look, there's a criteria. This criteria is universally accepted as to how you get the best minds into it, whether from the Court of Appeal or from practitioners. Now, let me tell you something, which is pedestrian, and I think you can relate to this. Every 4 years, we have elections, okay? And every 4 years, judges are removed from their normal routine duties to go and man the electoral tribunals. That has an impact on civil and criminal cases, such that, as I said now in Lagos, you're having adjournments on applications for 2 years. What has been done about it? We've taken leave of our senses. So every 4 years it's getting worse.
What should we do?
There are many things we could do. We can either create more courts, make sure that they are manned by competent people. The dockets and the way in which you manage the current system has to be reviewed. There has to be, look, there may be need for an assizes such that during the summer, some very experienced lawyers come to sit over simple applications. There must be something done. I can't understand it.
Let me bring this in for both of you just before, as we wind down to, I know you say justice must not just be done, but it must be seen to have been done.
Absolutely.
So when members of the public begin to analyze judgments, not just from the quality of the judgments now, when they begin to think that, no, I don't think this should have gone in this particular way. In other words, members of the public don't think or don't see justice to have been done. What comes to your mind in terms of what the problem or challenges could be and how should we approach it, Mr. Ike?
You see, well, just like you said, justice must not only be done, it must be seen to be done. And when we talk about justice being seen to be done, it's no longer in the purview of lawyers because the lawyers will understand that justice probably has been done, either technically or according to the books. But it has the man, the taxi driver, the Okada rider, the man who is in the street, seen justice to have been done. Those are the people we are talking about. You see, the general principle is that the courts do not make their decisions based on public opinion. Beautiful. But you see, the adjunct principle to it is that there is also a court of public opinion outside there that the court is aware of. Otherwise, we won't be talking about justice being done and seen to be done, because we are now talking about somebody who is outside the court.
I need to bring Mr. Obama just before we wrap up. Please, go ahead.
I know what you have in mind is the emo judgment, and you keep...
No, not necessarily. Right. Not necessarily. I'm talking about a broader perspective.
So, oral advocacy plays a uniquely significant role in the common law jurisdiction and all the systems that are modeled upon it. So if I go to the Supreme Court and I'm not permitted to explain, take the Imo case, for example, I read it. There was no debate either, well, maybe there was by counsel, but in the judgment, on what should be the remedy. Let's assume that the court was right. That remedy is key, because if you had asked for a rerun, perhaps there'll be more confidence.
Okay, we'll have to go at that point. We'll have to thank both of you for coming on. Mr. Osaro Ehobamia, Senior Advocate of Nigeria, and Mr. George Eke, a legal practitioner. Thank you both for coming on this morning.
Thank you.
We're back in a moment. Stay with us.